Hi, my name's Ellen Scult, and I'm an attorney who works in Wayland, Massachusetts. And I'm holding up my name just for 2 seconds so you could see the spelling if you do need to get in touch with me to answer some questions. So I'm going to give a talk today on guardianship, and I'll just jump right in. So when a child reaches the age of 18, he or she is presumed to be a competent adult with the ability to make all decisions, all medical decisions, living choices, education, finance, everything. And this change in legal status is often surprising to parents, especially if their child has intellectual disabilities or mental illness that makes them unable to make safe, reasonable, or appropriate decisions. So a guardianship, which I'll be speaking about, is a court proceeding where the court appoints a guardian to make decisions for someone else. So how do you know whether you need a guardian for your child? You can ask yourself, can your child make safe decisions, reasoned choices regarding medications, medical procedures, living arrangements, education, other life choices? Will you have access to information you need, school records, social service records, medical records? Can your child sign a healthcare proxy or a durable power of attorney? And does your child need antipsychotic medications or other more extraordinary treatment that they may need help making decisions over? So these are some things you should think about, but the most important determination of whether a guardianship is appropriate is whether your child would be considered incompetent under the law. So if your child is not incompetent, if your child can understand a healthcare proxy, and a healthcare proxy is a document where the child can sign and appoint somebody as their healthcare agent. So if they are incapacitated, if they get hurt, if they have a mental illness and they're having some sort of mental episode that makes it impossible for them to make decisions, a healthcare agent, whoever they pick, would jump in and take over at that point to make decisions. It's called a springing power. It's not always in existence. It's only when the person who signed the healthcare proxy is no longer competent, and they need to be competent when they sign it. Another document a child could be competent to sign is a Hipaa Release, which is a release just for medical records, and you can add in it your ability to speak to doctors. A Hipaa Release does not give you the ability to make medical decisions, but it gives you access to information. And finally, there's a durable power of attorney. And a durable power of attorney is a financial document. It allows you to handle finances for your child, dealing with bank accounts or investments, or make contracts for your child. It does not take away their ability to do those things also. So you each have the same rights to make these decisions regarding your child's finances. All these documents require your child to be able to understand what the document is, who they want to be making these decisions, and an attorney who they would be signing this in front of would have to be comfortable they understood it. And all those documents can be revoked at will. So if your child decides they no longer want you involved, they can revoke them. So if your child doesn't have the ability to understand a healthcare proxy or durable power of attorney, it may be appropriate for a guardianship. And for a guardianship, they need to meet the definition of an incapacitated individual. So there are two different definitions. One definition deals with intellectual disabilities. And an intellectually disabled person is defined as an individual who, before the age of 18, demonstrates significant sub-average intellectual functioning along with limitations in adaptive skill areas such as communication, self-care, home living, social skills, self-direction, health and safety. And this is considered a permanent condition, and it starts very young. The other definition that would come under a guardian for incapacity is mental illness. So if a child develops mental illness at any age, can be definitely after 18, they can be considered incapacitated if they are found to have a clinically diagnosed condition that affects their ability to receive and evaluate information, or to make or communicate decisions, and that which renders him or her incapable of making essential decisions regarding health, safety, or self-care. So those are the two definitions. So do all children who have intellectual disabilities need a guardian? No. It is extremely difficult to know whether or not a guardianship over an intellectually disabled family member is needed. You really need to evaluate what decisions they can make for themselves, and what concerns there are about making safe decisions. And the good news is that even though guardianship is a really big step, because it involves taking away an individual's rights and giving them to somebody else, the new guardianship laws really emphasize that it's not an all or nothing proposition. So there's a focus on limiting and tailoring guardianships to allow individuals to continue to have autonomy and decision-making over areas that they can make decisions over, and to give other decisions to the parent or the other, any other person appointed as guardian. So what is a guardian? A guardian is a court-appointed fiduciary who is authorized to make some or all of a person's personal needs decisions. So medical decisions, housing decisions, social and educational need decisions, vocational decisions. A guardian can apply for benefits and insurance, and is an advocate for the individual. So, and a guardian's decisions should always take into account the opinions, values, and choices of the incapacitated party as much as possible. So who can be appointed a guardian? A parent, a sibling, a family member, a family friend, a professional. They have to be over 18, and the court has to find that they're qualified. A parent has priority to be appointed, and all people get a criminal background check, a CORI check, and more than one person can be guardian. You can plan for succession. You can have a sibling and a parent. You can have two parents. Just as just something to think about, there are some programs where a parent can get paid a stipend for caring for their own children living at home. It's called the Adult Family Care Program, and there is another program. And under these, a parent cannot be a legal guardian and get paid. So if somebody is caring for someone with special needs at home and they have a guardianship, usually only one parent will be guardian and the other will be a caretaker if they qualify for the adult family care programs. Just something to think about. So how does a conservatorship differ? So a conservatorship deals only with finances. So a conservatorship is appropriate if there are assets and the individual is unable to handle the financial matters, and the funds are in danger of either being wasted, or if the person's in danger of being taken advantage of because they are too trusting because of their intellectual disabilities. You should look into a conservatorship. But a conservatorship is only if the individual has money. So just the small amount of money they make in a special program would not be enough. A guardian could handle that. We're talking about money such as money that the grandparents leave to them. And so there's a chunk of money, or there could be bank accounts or stocks or things like that. And often in those cases, you can do a single transaction conservatorship and put these funds or put this money in a special needs trust. And so then you don't need continued court oversight, because trusts are not part of court oversight, and you can protect the funds without actually having to do accountings and everything that a conservatorship has, that a conservator has to do for the conservatorship. So let me tell you a little bit about the guardianship process. So the process itself takes several months, and truthfully, since COVID, it takes even more. It's more unpredictable. So if you are concerned about having the conservatorship the guardianship before your child turns 18, then you should start several months beforehand. But if there is ever an emergency situation, such as your child needs oral surgery and they're 18 and the guardianship hadn't come through, you can get a temporary guardianship for an emergency reason. So there are ways that can cover your child if you don't have a guardianship in advance. But so a guardianship, the thing that takes longest to file a guardianship is the clinical team report. And a clinical team report is it's like a medical certificate, which I'll talk about also, except it needs to be signed by 3 people, a licensed psychologist, a registered physician, and a licensed social worker, all who are either familiar with the child or assembled just for just to do this report. And these professionals all sign the same form. They look at tests, they look at intellectual and adaptive and evaluations. They look at diagnoses, level of intellectual disability, and impact on informed decisions. It's a very inclusive document, and it goes in detail about what your child can and cannot do. Part of this is to limit the guardianship, but part of it is just so the court really knows what functionally the child is capable of. And this document, which takes a while to get, is good for 6 months, which is great. If somebody does not have an intellectual disability but has mental illness, you use a medical certificate, which is a less involved document, although, and it is only signed by a medical professional. And it also goes through what the person can and cannot do, and what their diagnosis is. And a medical certificate can go through both, is needed both for guardianship and a conservatorship. But it is a less involved document, but it's only good for 30 days. So if you get a medical certificate, which you need to file the guardianship, you will need another one by the time there's a hearing, because you can never get a hearing within 30 days. So you would be filing one of these medical documents, the medical cert or the clinical team report, along with a petition. And the petition is pretty basic. You give information about the proposed guardian, the incapacitated person, family members, because family members get notice. So siblings will get notice, or if there are no siblings, then it depends on if there's somebody they've lived with for the last 60 days before you filed the guardianship. It may just be that the parents get notice, but if somebody who isn't a parent is filing for this, then the parents and the siblings would get notice. So the petition gets filled out, the medical certificates, and a bond. So a bond is just a form that you write down what you believe the assets are of the person, which are usually minimal for most guardianships for intellectually disabled kids. And you just sign it. There's no sureties. You don't have to pay for it. It is just basically saying that you will take this job seriously and be ethical about it. So these get filed with the court, and the court generates a citation or a notice of the petition. This needs to be handed to the person over whom you're trying to get a guardianship in hand, and everyone else can get notice by mail. People can assent to it if they agree to it. And a citation has an objection period. It's usually 30 days from the day it's generated. So for those 30 days, you have to wait to see if there's an objection filed. And the only person who would really file an objection, I assume, so doesn't usually happen with children, but with adults, there can be fights between siblings as to who should be guardian, or a parent over whom guardianship is, they're trying to get guardianship may object. So those kind of things can happen with older people. And with a Rogers guardianship, which I'll explain a little bit later, where you're asking for permission to administer antipsychotic medication, the court appoints an attorney to represent the incapacitated party, and that person may object. So after the objection period ends, then usually the court will mark it up for a hearing. Used to be in the old days, you would mark it up yourselves, but now the court generates their own markup date. And they've been on Zoom in the past 6 months to a year, but now they're starting to be in person. But whether the child needs to attend the hearing depends on what was checked off on the clinician's report or the medical certificate. There's a part that says whether or not it would be harmful for the child to attend. Lately, as the hearings that are on Zoom, there's been much more participation by the children, and I believe you can still request that hearings are done virtually, and then your child can participate if they want to. So at the hearing, the judge will determine whether the child has an intellectual disability under the definition I had told you earlier, which I'm sure everyone's memorized, and with an uncontested guardianship, the hearings last less than 5 minutes, and a guardian is appointed. And the responsibilities of a guardian, once you're appointed, if it's not a Rogers, it's not a medical guardian, if it's not a guardianship with antipsychotic medications, then it lasts until you ask it to be terminated. And each year you're required to file a care plan, and that would be your obligations to the court. If there are antipsychotic medications needed, then as I say, the court appoints an attorney for the incapacitated party who is present and will talk to their client and see if they want the medications. There will be more information before the hearing. A doctor has to sign a clinician's affidavit saying that the person needs these medications. A treatment plan is filed that discusses the range of medications that you're allowed to give the person. And you do findings of fact regarding those. You talk about the side effects and the pros and cons of taking these medications. And when the judge rules in a Rogers case, you have many more instructions regarding the medications. And those hearings take longer. And then the Rogers guardianship is in place permanently, except the medications, the treatment plan need to be renewed every year. So every year you need to file a new clinician's affidavit, new, a monitor has to, the person who's the guardian needs to write a report. And there are the Rogers counsel, the attorney has to see the person and make their reports. And there's something called a, and it's an uncontested process where you can file everything online and you don't have to appear if everyone agrees and the treatment plan does not change or get worse. If it gets less, it can still be done just online administratively. But if not, you have to go in if you need changes that make it more, more medications, then you have to go into court. And so those are the basics regarding guardianship. I did want to say that it is important for the, when you're doing a petition, that you put down any limitations to the guardianship. If your child can't make medical decisions, but certainly can make all their social or educational or vocational decisions, you put that in the petition itself, and when the court order or decree comes, those limitations are part of the decree, and you'll get letters of guardianship that set out what your powers are and what powers are retained by your child. And conservatorships can also be limited. So if you do have a conservatorship and you don't do the single process where there's a, maybe you can't, where there's a trust, you can have a situation where the child has a certain amount of funds that they use on their own for anything they want, and that the rest of it or different parts of it are managed by the conservator. So that's it. Usually now I ask for questions, but I guess not. So anyway, if you do have any questions, again, my name's Ellen Scult. You can give me a call and I'd be happy to answer your questions. Thanks.